had to go to the sheriff. He couldn't hire her, he couldn't fire her, he couldn't promote her, he couldn't demote her. We had this Supreme Court case come out, and I provided that to the 10th Circuit. Well, they found, I think that they just kind of ignored the Vance decision, even though they read it, they cited it in their brief. They ultimately found that there were issues of fact as to whether or not he was a supervisor or not. They said if the sergeant had or appeared to have the power to take or substantially influence tangible employment actions. Now, the Supreme Court said if they could and did do substantial employment actions, but this was if he had the authority to it or if he appeared to have the authority to it. Okay? If he could influence tangible employment actions, not even take tangible employment actions, but influence it. And they said that because he could give recommendations to the sheriff for a tangible employment action, that was sufficient. That if he could influence tangible employment actions and use the threat of taking such actions to subject her to a hostile working environment, then the county would be vicariously liable for his severe or pervasive sexual harassment. So they looked at it and said, not only did he have authority, but he had maybe apparent authority. Or in our particular case, he told her that he had authority, she claims, which he never had. And the 10th Circuit said that that would be enough to classify him as a supervisor, and therefore get us to that really bad place that if he was the harasser, then we would have been sunk. So they found that he could do that, and they remanded it back. We ended up resolving the case. We would have tried it. I think that the evidence would have shown that he was not a supervisor. The court did go on, and we got some very good rulings from the court. And if you all, I've got copies of the decision in the back. The court did give some very good guidance on tangible employment actions. Remember, if the supervisor was the harasser and took a tangible employment action, that's where you're sunk. Okay. In this particular case, they argued that the sergeant controlled her schedule, and that at times he placed her on what's called the magnetometer, you know, the security thing that you walk into in courts, when she wanted to have road experience. And he put her there, and that was not a desirable place. They also argued somehow, they tried to argue that rape was a tangible employment action. Rape is not a tangible employment action. But the court looked, and they looked at various things, and they found that he did not have a tangible employment action. There was no tangible employment action against her. So, even if he was deemed her supervisor, there wouldn't be this strict liability because there was no tangible employment action taken. And the case that I've got copies back there discusses all the different types of conduct that the court found were not tangible employment actions that I think would be good for you to look at, because those would be helpful. Like things like denying leave time, she wanted time to take off for vacation, etc. They found that was not a tangible employment action. He gave her a bad performance evaluation and then corrected it. They found that was not a tangible employment action. Denying her road training, they found that was not a tangible employment action there. So we knew we weren't sunk if we had to take the case to trial, but we ended up getting a pretty good resolution of the case, because I think plaintiff's counsel realized that when there's no tangible employment action, your case kind of goes down the tubes. But what concerned me in this particular case was the question as to whether or not there was a supervisor, whether he was a supervisor, and they clearly did not follow what the United States Supreme Court had to say. So, there you are. Questions?
This is really interesting. At the last employer that I worked for, we had a lot of people in lead positions that were technically not the supervisor, so they couldn't hire or fire, but they had the ability to influence tangible employment actions in every other sense of the word. They could reassign, they could deny leave, they could do everything but discipline and terminate.
Yep.
So I wonder if they're looking at that case as he was in that lead capacity, or at least in the plaintiff's mind, and that's why they decided that he was a supervisor.
Probably so. And that's where we're going to run into problems, I think, in the future, is there are a lot of positions that are lead positions. They may be low on the totem pole, but they're over somebody. And if they can affect their tangible employment, yikes. Especially, if they start harassing, that's not a good thing. So yeah. Any other questions? Yes.
This is for Richard, to help Richard understand. In the BYU case, was the student that turned the wrong way when the BYU cadet directed him, was that a student from a rival university?
It was probably a BYU student, not knowing how to follow the directions.
I think we found the shark.
Any other questions? Johnny, yeah?
I'm just wondering about the supervisory situation. I mean, one issue I think that personnel directors and commissioners need to look at is the extent to which they provide supervisory authority to people within the county. That if you have department heads that are delegating supervisory authority to pretty much everyone in the department, you just multiplied your risk many times over, because you end up in this, you're guilty until you prove yourself innocent, and you don't have any defenses to prove yourself innocent. So I think that's the first question is, look at the amount of authority that you're giving to people to put them in that supervisory capacity, and see if that's what you want to continue to do, or if you want to start to limit that.
Right.
And very clearly identify who is the supervisor and who is not. And then I wonder, Kristen, once you've done that, would it be helpful to have that part of your training with your employees to identify, at their performance appraisal, to tell them, this is the person who's your supervisor.
Yes.
Anyone else who says they're your supervisor, they don't have authority to control your job. Would that be helpful?
Sure. Absolutely. I mean, there should be a clear identification as to who is the supervisor. Who do you go to with problems, with questions, with concerns? Who can truly affect your employment? Even though, the guy next to you says that they can they really? Yeah. I mean, I have a case right now that it's not a governmental case, where it's an oil rigging company. And there were some nasty things that were done and said by both sides, back and forth. So nobody's clean in this one. But my question was this person A, person B's supervisor? And the answer I got was, yeah, this person A was really low on the totem pole and didn't supervise many people, but maybe one or two. And this employee B was one of them. And he actually demoted him. And I thought, oh boy, that's a problem. Any other questions? Okay, that's all I have. Thank you very much.